Good day to you and welcome to another Paddocks Club video tutorial. Today I would like to address a topic that has often been raised on the discussion forum: visitors in sectional title schemes. A visitor is not defined in the Sectional Titles Act or the prescribed rules. My book has defined a visitor as anybody not permanently resident in the scheme. I would like to add that a visitor is any person who is an invited guest or any of the owners or occupiers. There are many categories of visitors. A visitor could be a family member, a friend, a colleague, or a service provider. This leads to the next question: when does a visitor become a resident? There is no explanation for the distinction between a resident and a visitor. Nights per month spent in the scheme seems to be the most common measure for the distinction. Where a visitor stays over every weekend, it may be that the visitor becomes a regular resident. It could also be that visitors stay for a week at a time, thereby exceeding the amount of people allowed to stay in the flat. This becomes an issue of overcrowding. If the scheme has a rule restricting the number of persons occupying a particular sized flat, the trustees must enforce the rule reasonably. The body corporate could also make a conduct rule dealing with a period of time for which a visitor can reasonably stay over at any owner or tenant. And Anton also pointed out in a discussion forum post that some schemes issue a limited number of overnight parking tokens to residents for the use of their visitors. A related issue is how many visitors any owner can entertain at any one time. The body corporate should not adopt overly restrictive rules in this regard, because where an owner celebrates their birthday and during festive periods such as Christmas, it's reasonable to expect that residents would entertain more than usual. Where one resident on a regular basis entertains numerous visitors at any one time, it could put pressure on the visitor parking bays and cause noise nuisance to other residents. Therefore, residents should always be considerate that they reside in a community scheme. The next consideration is whether the trustees can regulate access to the common property by visitors, for example by asking them to provide identification when entering the scheme. Graham answered a similar question on the discussion forum. In his view, you will need a specific rule that authorizes the body corporate to require visitors to identify themselves before being allowed into the scheme. The making of such a rule will ensure that such a measure is supported by the substantial majority of owners. Deirdre also asked a question on whether it is acceptable for visitors to bring their pets along with them to the scheme. Anton advised that the applicable pet rule at the scheme should be the guide. A visitor has no more extensive rights than the resident that he or she visits in respect of the use and enjoyment of the common property. Therefore, if there is a no pet rule, owners would need to ensure that their guests do not bring their pets when they visit. He added that guests must also observe any existing rules regarding the use of leashes, cleaning up, noise, etc., and should show normal consideration to the community scheme in respect of their pets. Graham's point of departure is that a visitor to a scheme has no right to bring any pet into the common property, whatever its rules in regard to the residents keeping pets. But he added that where it is practical for a visitor to make an advance request to the trustees for permission to bring their pet when they visit, then depending on the circumstances, it could be considered reasonable for the visitor to bring their pet along. The final discussion relating to pets is whether the scheme rules are binding on visitors. Section 35(4) of the Sectional Titles Act provides that the rules bind the body corporate and the owners of the sections and any person occupying a section. How are visitors' actions then regulated? Prescribed Management Rule 69 states that the provisions of the management rules and of the conduct rules and the duties of the owner in relation to the use and occupation of the sections and common property shall be binding on the owner of any section and any lessee or other occupant of any section, and it shall be the duty of the owner to ensure compliance with the rules by his lessee or occupant, including employees, guests, and any member of his family, his lessee or his occupant. What is the extent of the owner's liability for actions of their visitors? Well, the imposition of the duty on owners to ensure compliance with the rules has been widely interpreted as the imposition of strict liability, which implies that the body corporate can fine and otherwise act against an owner on account of the actions of his visitor when they act in a manner alleged to be in breach of the rules. Another interesting topic relating to visitors is visitor parking bays. This issue is meaty enough to address in a separate video or article in the future. Thank you for joining me. If you haven't experienced any problems with visitors in your scheme, please post your comments or questions on the discussion forum.